give some evidence. So, and it's the defense that brought it up. So, can you elaborate on that, Tom?
Yes, Your Honor. Does the court remember? Well, we were not on the record yesterday afternoon, so I can go ahead and just put a little bit of information on the record to exactly what we're talking about. This case is involving a collision involving death that occurred on September 1st, 2022. When the officers made the scene to respond for the bicyclist that was in the road, there were no witnesses.
Can you say that again?
Sorry.
Respond to the what?
To the body that was in the road. There were no witnesses found at the scene. There was very limited debris, evidence that was collected, any of that stuff. So the detective made the scene that evening, did what he needed to do, collected the evidence he wanted to collect, and started the investigation. The next day, on September 22nd, there are 2 calls that go into either 911 or the non-emergency line. One is made by my client, Mr. Relics, where he calls 911 to report that his car has been stolen from the driveway. I believe this comes out around 8:30 in the morning. At almost the same time, a different person calls 911 to report that there is a vehicle that is in front of her house. She does not recognize it, and it appears to be damaged. BCSO officers go to Mr. Relics' house to take the report for a stolen vehicle, and SAPD officers go to the vehicle that was in front of the street that's on the street named Laguna Falls. So we have 2 separate areas and reports that are being taken. When the officers, SAPD officers that go to Laguna Falls, they see this vehicle, they run the license plate. There's a lot of different steps that are taken when they're processing this vehicle. In conferring with the prosecutors, and it may have been a misstatement by the prosecutors, but there was discussions as to whether or not this vehicle was processed and taken and impounded because it was abandoned property. There's information in the police reports by one of the CSI officers who did the processing of the vehicle, saying that she processed it for a stolen vehicle. And then there's going to be the question that comes in later when the detective links up the 2 accident scenes and links everything up as to whether or not they're processing it for the crime of this actual accident. So in the initial processing of the vehicle on Laguna Falls, the CSI officer, I believe her last name is Hunt, and the officer that made the scene at this time, when they're processing this vehicle, they search this vehicle, not only taking pictures of the outside, but also taking pictures of the inside and collecting evidence. They did it without a warrant. And that is why we are objecting, because later it is determined that some of the blood evidence that's in this car belongs to my client. So what we are saying is that this was a warrantless search. And even though my client had reported the vehicle stolen, there is still an expectation of privacy that he has to this vehicle. And there are limits as to what the officers can and cannot do when they are processing this vehicle. So that is why I'm objecting to this, the blood that's taken. It may be that we can fully do it in proper, or it may be that the CSI Hunt needs to come in and testify to be able to specifically discuss SAPD policies. I have it printed out for both abandoned property as well as recovery of stolen property as to what the limitations are according to SAPD policy when they're processing something like this. So that is why we're objecting.
Okay. State.
Judge, first of all, I would like to say that I'm still confused on the avenue that we're going here. We haven't attempted to introduce the blood yet. The proper time to object is when we move to introduce it. There's no motion on file before this court. Therefore, there's nothing for the court to hear at this time as regards to the admissibility of evidence that is yet to be introduced.
Just give me 1 second.
Of course.
Okay, and my question to the defense is, why did you file a motion to quash? I mean, a motion to suppress?
Because I wanted to wait for jeopardy to attach before I raised this issue, 1. But 2, the reason we're having this hearing ahead of time at this stage in the game, yes, it would be proper for the witness to be called when the state of Texas moved to introduce the evidence. then it would be ruled on, and we'd have the hearing outside the presence of the court, and the court would make the decision on whether or not it's admissible or inadmissible. The motion that's on file is a motion in limine. I was asking that the state of Texas not mention this blood evidence until we have that hearing and until there is the proper ruling. The state of Texas was the one that wanted to have this decision done before they did the opening statements. If they're perfectly fine not mentioning the blood evidence until it has been ruled admissible by the court, then we can proceed and we can just do this at the time that the officers come in.
But what I'm asking is, why did you file a motion to suppress? Because that's what's creating this quagmire. And without you attempting to suppress it before trial, then two things are gonna happen. They're gonna state what they expect the evidence to show, and they'll say, we have his blood on the steering wheel, the door, whatever. And then when the witness, I guess we would take the witness outside the presence of the jury, two things are gonna happen. I'm gonna rule it's admissible, or I'm gonna rule it's inadmissible, and they have to eat it. Okay, and then you can argue, they told you they were gonna bring you blood, and look, they didn't bring you blood. That's the proper way to do it.
Well, that's
not a motion of limine.
That's one of the ways.
And the proper way would have been a motion to suppress.
So I apologize, I've never tried a case in front of this particular court. However, there are different ways to be able to proceed, and it goes to the strategy of defense counsel. If we had done this as a motion to suppress and we'd done it before trial, the state of Texas could have appealed that decision and it gone up to the Fourth Court of Appeals. Whereas if we do it now, it would still be, we have jeopardy attached in it. Whatever evidence that the court has ruled is admissible is what goes to the jury.
Judge, I'm just gonna echo what you said. If we promise the jury blood and then they don't get the blood, that's our crossfade. We end up with the egg on our face. I don't understand what's happening.
I think you're asking me to do some sort of declaratory judgment. The issue is not right at this moment. It will become right at trial. And so we're not going to conduct this hearing. So you just you tell the jury what you expect the evidence to show, and then at the time that witness takes a stand, we'll take that witness outside the presence of the jury, and then I'll rule whether it's admissible or not under all your objections, but particularly either the Fourth Amendment or Article 1 of the Texas Constitution or 3823 of the Court of Criminal Procedure. Okay?
So it's my motion is limiting for them not to mention this until it's
that's the night.
Okay.
Okay.
Judge, can I?
Go ahead. Off the record?
Off the record.
Okay, so we're done with that.
Off the record.
This is Daniel James Kupala. Will Lord please state your name?
Nicholas Roof, the state of Texas.
Please header for Daniel Kupala.
Yes, sir. Are you Daniel James Kupala?
Yes, Your Honor.
Okay, and stated you're proceeding as charged.
We are, Judge.
And to you, sir, are you familiar with this indictment and the charge against you? You have the right to trial by jury, the right to confront and cross-examine witnesses, and the right to remain silent.
Yes, Your Honor.
And are you knowingly and voluntarily giving up those rights, including your right to have a trial by jury?
Yes, Your Honor.
Do you understand that if you are not a United States citizen, a conviction in this case would cause you to be deported, excluded, or removed from the United States, or denied naturalization under federal law?
Yes, Your Honor.
Counselor, did you explain those immigration consequences to your client?
I did, Your Honor.
And to you, sir, do you understand that state law prohibits us on your right to possess firearms and ammunition?
Yes, Your Honor.
Do you also understand that under federal law, a conviction in this case constitutes a lifetime ban on your right to possess firearms?
Yes, sir.
Are you satisfied with the services of your lawyer?
Yes, sir.
Okay, you have a plea agreement that causes the state to proceed on count one. They're waiving the deadly weapon finding. They're asking that your punishment be assessed at 10 years imprisonment, a fine of $1,000. You're applying for to a deferred
Probation.
probation. Okay, and the state is recommending that you get the probation. Outside the agreement, they're asking that I place you on supervision for 10 years, that you undergo a type evaluation, 100 hours of community service, no contact with a certain person, and that you undergo certain courses. Is that your plea agreement, sir?
Yes, Your Honor.
Counselor, is that the plea agreement?
Yes, Your Honor, we did have a request on the community service hours.
Okay, we'll get to that in a minute. Counselor, does your client have a factual and rational understanding of the charges against him?
I believe he does, Your Honor.
Has he been able to assist in his defense?
He has.
And in your opinion, has he not been found guilty?
Yes, Your Honor.
And to you, sir, to the offense of manslaughter, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, sir, are you pleading no contest because you talked it over with your lawyer here and you believe it's in your best interest to do so?
Yes, Your Honor.
Or you understand that even if you plead no contest, I can still find you guilty?
Yes, sir.
Are you pleading no contest freely and voluntarily?
Yes, sir.
Has anyone forced you, threatened you, or otherwise coerced you to get you to plead no contest?
No, Your Honor.
I find that he's voluntarily waiving his rights and he is mentally competent on accept this plea as the state has approved.
Yes, Judge. State offers State's Exhibit 1, including all attachments.
No objection, Your Honor.
Okay, there being no objections on the next state sworn, under this forced to plea and make it part of the record, and there be used with the Okay, based on his plea and the stipulations, I'm gonna go ahead and find him guilty. Manslaughter, 72. Okay, and Counselor, are you waiving the plea sign?
Yes, Your Honor.
Any objection of the state?
No objection, Judge.
Okay, Counselor, is there any legal reason why you should not sentence your client?
No, Your Honors.
Okay, then, having been found guilty, I'm gonna sentence him to 10 years in the Texas Department of Criminal Justice, Constitutional Division. I'm gonna suspend that sentence and place him on 10 years community supervision. What about the findings that are the community hours?
Yes, Your Honor, Mr. Capello was in high school when this happened. At this point, the court will consider holding this statement. He does work full-time and he's trying to get back to finish his GED so long as he is in school. And as well as the moral, with cognizant therapy, MRT, is pretty expensive. I'm not court appointed. He actually still owes me some money. I was going to ask if the court would consider lowering his fees as well.
Okay, so I'm gonna put a $1,000 fine. I'm gonna probate 500 of that. Another 90 days of weekly UAs and ETGs. Random after a staff evaluation aims to follow the recommendations. 100 hours of community service. I'm going to probate that for now. If you start violating, that'll kick in. No contact with Jennifer Alvarado. On the MRT, can I waive the fees on that? If there is there, no?
No, Your Honor.
Okay, the MRT program, I'm gonna hold it in abeyance for now. Again, if you start violating, you start smoking dope or whatever, then it'll kick in. The aggressive driving course. And then, in this case, does it come with any sort of driver's license suspension?
No, Judge, it's just a manslaughter.
As opposed to intoxication?
As opposed to intoxication.
Okay. Probation, anything else that you would recommend?
Your Honor, I would like field visits.
Okay, so we'll order random field visits.
Thank you, Your Honor.
Okay, then, anything else on the sentencing from either side?
Judge, I would just request based off some bond violations that happened beforehand, no possession of firearm. Obviously, because he's a convicted felon, he does not want to do that now, but just make it a term of his.
Okay, no possession of firearms. Okay, anything else from either side or probation?
Yes, Your Honor, there is a vehicle and some other random personal property. I don't think the state's opposed, and I believe the victim did have some property in there as well. We're asking if that be released.
We'll just file a motion for
Yes,
property to be, again, to you, sir, is that you should make from the property to the victim?
Yes, Your Honor.
I'm gonna, because I followed the plea agreement, you do not have my permission to appeal. I'm gonna give you and your lawyer a copy for your records. I'll tell you that, you know, this, situation here, this kind of offense, you know, usually carries a prison term. So somehow you're getting a second chance. I imagine part of it is your youth. Don't take it for granted. If you come back to me in this type of case, violating your probation, the odds are not good for you. Do you understand that? Okay, so I don't want you to come back someday and say, give me a second chance, because this is your second chance. Do you understand that? Yes, sir. Okay. That closes the record on this case. Thank you.
And Judge, we do have victims. I'm the mother of Henry Casas Jr., also referred to as my baby Henry. Baby Henry was the youngest of 3 kids and also our only son and the only brother. His tragic, unexpected loss has had a big impact in our lives, as well as my family. Baby Henry has been our first major loss in the family we've ever experienced. A close loss like this, like his, and don't know how we're supposed to deal with it. I have constant anxiety, I have nightmares, I can't sleep. I'm angry, I'm sad, I'm crying. My girls are sad. My girls are mad. His dad is angry. It's been so much to deal with. Every day, one of us is crying. Not a day hasn't gone by that one of us is not crying. His dad comes home from work and sits in his vehicle and cries. So my girls don't see him. Our son had so much to look forward to. He played baseball, football, boxing. He wanted to start a clothing business. He wanted to be a Marine. He wanted a future. He looked forward to a future. We, his family, looked forward to his future. He was only 14 years old, and now we have nothing. I hope your honor that the sentencing Daniel receives today teaches him the consequences of his actions of that night. That he understands that when you are a driver of a vehicle, it comes with responsibilities. Responsibility for yourself as well as your passengers. That he understands driving a vehicle is not a video game or something to use for fun and drive recklessly. His reckless driving has caused the death of my son who will never get back, no matter how many years or what he receives. He will never bring back our son. I just hope that he takes the experience for himself seriously and understands what he did, because he has destroyed our family's lives forever with his actions. You, Daniel, have given us emotional, financial, physical distress. You have given us pain that we will never heal, and I hope you think about that every time you sit in a vehicle.
This is from the sister. My name is Yanalek Casas. I'm the sister of Henry Casas Jr. I'm the middle child. I was born with a hearing disability that caused me to be deaf. Henry was 2 years younger than me, so me and him had a very close bond. He would say I was his little mama, and I signed his name, Baby. He was always annoying me, making me laugh when my dad sent him to throw the trash at night. He would tell me to go with him,